Assalamualaikum warahmatullahi wabarakatuh. We are from Group 6 in TLB 7 and we will be presenting about SYARIE Legal Profession Federal Territories Act 2019 or Act 814. It is a way forward for empowerment of Syariah law in Malaysia. My name is Balkis Amira binti Razali, matrix number 1253227, and I will start the presentation with the introduction. Before this act, things were honestly a bit messy. We didn't have a central law for SYARIE lawyers, so standards and discipline varied everywhere. It was very disjointed. This act, Act 814, changed the game. It moved us away from just general administration and created a professional framework. We now have the Majlis Peguam Syari'i to oversee practitioners and a strict 6-month pupillage to ensure everyone is highly qualified. The goal here is simple: to make sure SYARIE lawyers are held to the same professional prestige as the civil lawyers. While it only covers the federal territories for now, it is designed to be the gold standard for the rest of Malaysia to follow. Now, let's look at what the situation was like before this act came into play. To understand why this act is so significant, we must first look at the landscape before its existence. Before 2019, there was a major institutional gap. There was no specific federal legislation to regulate SYARIE legal practitioners. Instead, we relied on a fragmented system of court practice directions, administrative rules, and non-uniform state enactments. This created inconsistency across the board. Two landmark cases highlight why a new framework was necessary. First, in Sulaiman Takrib and Kerajaan Negeri Terengganu 2009. In this case, Sulaiman Takrib challenged the state's power to create Syariah criminal laws, arguing that crime should be a federal matter. The federal court eventually ruled that the states do have the power to legislate on Islamic offences, but here is the catch. While the court confirmed that the Syariah court is constitutionally powerful, it said absolutely nothing about the people representing the parties. Back then, the court was recognized, but the supporting profession was unsupervised. There were no set rules on who was qualified to stand in front of the judge or what ethical standards they had to follow. This created a massive institutional gap. Second, in the case of Latifah Mat Zain and Rosmawati Sharibun, this second case is even more critical because it dealt with jurisdictional conflict. It wasn't just a simple family dispute, it involved complex constitutional law and Islamic inheritance faraid. The federal court ruled that Syariah matters belong strictly in Syariah courts, but the case highlighted something deeper, which is the Syariah disputes are legally complex. They are not just religious talks. They require deep knowledge of procedure and civil Syariah overlaps. The problem before 2019, anyone admitted under different state rules could show up as a lawyer. There were no uniform training in constitutional limits or professional ethics. This case proved that if we have complex laws but no guaranteed quality of legal representation, the effectiveness of the entire court system is undermined. In short, these cases prove that while the courts existed, the lack of statutory framework for lawyers was a missing piece of the puzzle that needed to be fixed. Forward to the SYARIE Legal Profession Federal Territories Act 2019 analysis. This act was specifically designed to fill those regulatory gaps in Kuala Lumpur, Putrajaya and Labuan. Its core mission is simple: to provide a clear, uniform system for admission, conduct and discipline. The act introduced two vital statutory bodies. First, the Qualifying Board to manage admissions and qualifications, and second, the Majlis Peguam Syari'i Wilayah Persekutuan to oversee professionalism and enforce disciplinary measures. As noted by Datuk Dr. Mujahid Yusof, this structure allows for the creation of special legal aid units similar to those in civil courts to look after the welfare of Syariah lawyer and the public. By setting these clear ethical standards, the Act does more than just regulate. It strengthens the entire Sharia court institution and boosts public confidence. Although it is currently limited to the federal territories, the vision is for this act to serve as a benchmark and model for other states in Malaysia. It aligns with the Sharia legal profession with the modern professional norms, bringing its regulatory structure closer to that of the civil legal profession. In conclusion, the 2019 Act represents a remarkable step forward in professionalizing Sharia law, ensuring that practitioners are held to the highest standards of accountability. That's all from me, and I will pass this presentation to the next presenter.
Good day everyone, my name is Nur Inshira Najwa binti Muhammad Nurhaizan and my matrix number is 1250802. Today, I will discuss the structural and regulatory challenges faced by the Sharia legal profession in Malaysia prior to the enactment of the Sharia Legal Profession Federal Territories Act 2019. As shown on the slide, there were three main pillars of concern: the lack of a legal framework, weak disciplinary mechanisms, and inconsistent firm registration. Now, looking at the first column, which is the most critical challenge, was the absence of a specific statutory framework to regulate admission and ethics. A prime example is the mandatory practical training, or known as chambering. Unlike the civil legal profession, which mandates a strict 9-month pupillage under the Legal Profession Act 1976, Sharia practitioners were admitted based on varying state-level rules. Some states even bypass formal training entirely. This lack of standardization means a practitioner could establish a firm without sufficient procedural exposure, leading to inconsistent professional standards across the country. Now, moving to the middle column, the profession suffered from weak recognition due to underdeveloped disciplinary mechanisms because there was no centralized regulatory body to monitor and enforce standards. Professional misconduct often went unchecked. This lack of oversight significantly limited the credibility and institutional standing of Sharia lawyers within the broader legal system. Without a formal body to answer to, it was difficult to maintain a high level of public trust and professional prestige. Finally, the third column highlights the inconsistencies in firm registration. Before 2019, there were no detailed rules regarding minimum experience or firm name restrictions. Practitioners could essentially establish a firm based on personal discretion rather than standardized criteria. While civil law firms were registered with the Malaysian Bar, Sharia firms were registered with the Companies Commission of Malaysia, or SSM. This underscored a major gap, which the desperate need for a dedicated professional body, a Sharia Bar Council to harmonize and regulate registration practice. To wrap up, the absence of a unified regulatory framework reflects a systematic marginalization of the Sharia legal profession. These challenges hindered institutional growth and prevented the harmonization of Sharia law practice. It was these very issues that made the enactment of the 2019 Act a necessity for immediate reform. While the Sharia Legal Profession Act 2019 marked a progressive reform for the profession, a closer look reveals several limitations. This issue prevents the Act from fully empowering Sharia lawyers on a national scale. As shown on this slide, the limitations can be divided into two main areas, which is territorial scope and the lack of nationwide adoption. The first significant limitation is that the Act is only applicable within the federal territories, specifically Kuala Lumpur, Putrajaya, and Labuan. The reason for this restriction is constitutional. Islamic matters, including the regulation of SYARIAH lawyers, fall under state jurisdiction. Because of this, the Act cannot automatically extend its reach to other states like Selangor or Johor. This creates a major hurdle because we still lack nationwide uniformity. As a result, we still see different admission requirements, training standards, and ethical codes depending on which state you are in. Essentially, the benefits of this act are trapped within the federal territories. The second issue, as seen in the right bubble, is the limited adoption of this framework by other states. This leads to what we call regulatory fragmentation because there is no formal system to different states to recognize each other's lawyers. The professional mobility of SYARIAH practitioners is strictly limited. For instance, a lawyer registered in Kuala Lumpur must deal with different and separate rules if they want to practice in a neighboring state. Even though the Malaysian Bar has recommended that the other states to use this act as a model for harmonization, most states have not yet formally adopted it. This underscores a structural weakness which this act cannot solve the problem of inconsistency if it remains localized for the federal territories. This act is a great achievement for the federal territories, but its impact is still limited to a small area. To truly empower our profession and make it equal to the civil legal system, we need all states to accept and use this law. Only a unified national system can provide the consistency and recognition that SYARIAH lawyers deserve. That's all from me.
Bismillahirrahmanirrahim. Assalamualaikum warahmatullahi wabarakatuh. My name is Siti Nuri Najwa binti Tarmizi and my matrix number is 1251058. So today I will present to you on the benefits of SYARIAH Legal Profession Federal Territories Act 2019 to the legal field. So the first one is on the standardized regulations and admission. This act provides significant benefits by introducing standardized regulation for SYARIAH legal professionals. This can be seen or can be proven through the formal establishment of SYARIAH Legal Profession Qualifying Board, which centrally regulates on the admission standards, the training, and also the professional conduct of SYARIAH legal practitioners. One key example that we can see is the pupillage period across all federal territories in Malaysia, which is fixed at 6 months for SYARIAH lawyers. While this act actually formally applies to the federal territories only, but it is also designed to serve as a model so that other Malaysian states can adopt into their own state laws. This actually has been reinforced by the calls from Malaysian Bar for its incorporation nationwide. Okay, now we will move to the second benefit, which is this act improve and elevate the status of SYARIAH lawyers, placing them on par with civil legal practitioners. This is achieved through the establishment of Majlis Peguam SYARIAH, which functions similarly to the Malaysian Bar Council for civil law. Also, this professional body actually safeguards the ethical standards, regulates professional conducts, and also uphold the integrity of SYARIAH legal practitioner. In this act, there is also a specific part which governs the disciplinary proceeding. This may contribute positively to the public trust while also reaffirming that Sharia law is no less significant than the civil law in ensuring justice and also in ensuring social order. Apart from the two benefits that I have mentioned before, this act also benefit the legal field by streamlining the admission and also the professional practice of SYARIAH lawyers. It actually provides a clear and structured pathway for future legal practitioners by having specific provision that talks or set out the conditions of admission as a Syariah lawyer, which include, for example, the requirement of a Syariah lawyer that must be a Muslim, attain the age of 21 years old, good character, etc. And this clarity could reduce the ambiguity, particularly to those applicants who intends to apply as a Syariah lawyer in federal territories. So what happened next? This contributes to a greater consistency in legal representation, also to facilitate the admission of Syariah lawyer in our country. Now, let's move to the second part of my part for this presentation, which is the comparison between the two laws mentioned in the slide, which is the Administration of Islamic Law Federal Territories Act 1993 against the Sharia Legal Profession Act 2019. Okay, some might argue that why do we need this new enactment? Why this enactment is necessary? Because we already have the previous law, the first law, right? So let's get through the comparisons between both of the laws. Okay, the first one is on the legislative scope. Okay, as for the scope of Act 504, which is the first one, it is broad and it serves as administrative legislation, including the issuance of fatwa, religious Islamic authorities, and so on. And the regulation of Sharia lawyers under this Act was not its primary focus, but just like a mere administrative framework. In contrast, the Act 814, which is the Sharia Legal Profession Act 2019, it has a narrower or like a targeted scope. It because the enactment dedicates a statute solely for Sharia legal practitioners. Hence, by separating the regulation of Sharia lawyers from the general administration, we can see that the new enactment reflects a positive shift towards the professionalism of Sharia legal practitioners in our country. Next, the other comparison that I would like to highlight here is on regulatory framework. Under the Act 505, which is the first one, the regulation of Syariah lawyers was delegated to Majlis Agama Islam Wilayah Persekutuan through its power to make laws. This results in subsidiary legislation such as the Peguam Syariah Rules 1993. For your information, because of the enactment of Sharia Legal Profession Act 2019, the previous rules mentioned were revoked, in which it is in section 59. So now it has been replaced by the new law. Okay, back to the comparison. The Sharia Legal Profession Act established comprehensive framework through the Sharia Legal Profession Qualifying Board, as I have mentioned before in previous part, which is the benefit part. Okay, also they have Badan Peguam Syariah and Majlis Peguam Syariah. Therefore, this will structure development and power Syariah law in our country. Okay, everyone. Now we have almost come to the end of our group presentation, and we would like to suggest two recommendations regarding our topic for today. The first one, other Malaysian states are highly encouraged to adopt similar legislative frameworks, and for our topic, we suggest other states to adopt the Sharia Legal Profession Act 2019. The efforts to integrate these frameworks across all states can improve institutional cooperation, harmony, and also consistency in the legal field. Second, the creation of more formalized frameworks are recommended to enhance the quality and uniformity of legal practice, beside providing clear standards that all states can follow. This is highlighted particularly for formal or also for procedural matters. Hence, these measures will not only benefit some region of the state or like some region of the country, but also providing positive impact throughout our country, Malaysia. In conclusion, the Sharia Legal Profession Act 2019 marks a significant step towards the empowerment of Sharia law in Malaysia. By establishing a defined and clear legal framework for Sharia lawyers, the Act addressed ambiguity besides also filling the gaps left by previous law, which is Section 59 of the Administration of Islamic Law Act 1993. The new enactment standardized professional conduct of a Sharia legal practitioner and also ensuring them to act with integrity and also with full accountability. By elevating and improving the law, it can strengthen the quality in Malaysia's dual legal system, besides also to offer a better legal services by all legal professionals. That's all from us. Thank you.